Thank you very much for joining us. I'm glad you guys are doing this to help expand the communication so that we're all coming into hearings with the same expectation. Um, I wanted to comment on the evidence portion of the hearings, where the parties are not in agreement as to what exhibits are going to be put into evidence. They're going to challenge the exhibits. How is that done? If the exhibits are stipulated to or agreed to, they can go into the e-portal as supporting documents to the hearing. If they're not agreed to, not stipulated to, what has been going on in my division is they've been emailing it to the division, emailing it to my JA, and I get those documents off the email. I can, during the course of the hearing, put on a split screen so that the document is visible to the parties, to the attorneys, um, as well as what I'm looking at, and then they go through and lay the predicate. It's a less complicated method because it's a non-jury trial, and I've had no problem with if they don't lay the predicate, then the exhibit's not coming in, and I'm not going to consider it. But it's worked pretty effectively. The action of taking care of exhibits and putting them in takes more preparation from the attorneys. You're going to have to get the exhibits ahead of time to me, ahead of time to the opposing counsel. If there's photographs, please be aware that we have no color printers available to us here at the courthouse, so that I can print the exhibits, mark them, and give them to the clerk. But they're going to be in black and white. And if a color photograph makes a difference to you, if it's important that we see it, such as coloring on an injury as to whether it's old, whether it's fresh, and so on, you're going to have to get those original photographs in color to the court, send it directly to the judge's chambers in my division, and in that I will substitute it in for the black and white that was actually sent to the clerk. We've got a hearing going on now that I took a lunch break for to do this. They've submitted videos. By submitting the videos to me via email, I can view them. I can make a ruling based on the videos, but I can't give them to the clerk until the attorneys send the videos to me on a thumb drive or some other movable mechanism that allows it to go into the court record in order to protect the record. So the hearings themselves take a little bit more advanced preparation by the attorneys, where it's an evidentiary contested hearing. And at this point, I'll turn it over to Frank for your observations. Judge Ledee.
Thank you very much, Judge Bailey. Most importantly, I'm glad that everybody is safe and hopefully everybody's staying healthy and that they're staying home. We are trying our best to make sure that we are ensuring continuity of the judiciary, especially in the family division. Division 33 is fully operational. My JA is working from home. She comes in on Monday and Wednesdays to print out the orders that you send her, and I sign them on those days. So if there's anything that comes up and you send her orders to be done, that's taken care of. My clerk has been with me since day one. We are still conducting hearings from the courtroom using Zoom and using telephone conferencing. And the most important thing is that we want to guarantee that you have access to the judiciary and to the family judges. So that's our primary concern. At the same time, I want to make sure that your clients know that we're there and that you can ensure that you can have hearings before us. So right now, most of the lawyers are all contacting my JA via email. We're operating on that system, just like we did before, and we're scheduling the hearings as we were before. As to the Zoom hearings, right now, the issues that I've seen are issues of swearing in folks, issues dealing with evidence and different types of evidence at trial. I've had 2 trials so far, and they've actually worked really well. The attorneys that handled trials before me went ahead, they did a complete list of stipulations, and what they did is that they submitted the stipulations on either on the portal, or they actually sent them to Barbara. And as I said, if it was under 20 pages, I printed up the exhibits so that they could be given over to my clerk and they could be introduced. So if you can do that ahead of time, that is critical. As to preparing an electronic trial notebook, if you can, prior to trial, The only way that we can do this efficiently is that you prepare an actual trial notebook and you prepare every exhibit with a summary of exhibits, ranging from exhibit A for identification to exhibit ZZ for identification, and that you make sure that the court has a copy of that exhibits, or that the exhibit list, as well as the exhibits, and scan each exhibit individually so that I don't have to literally redact the evidence. That is critical. Once we have that and we start the trial, we go ahead and I will go through with the parties anything that has been stipulated to. If there is any evidence that's been stipulated to beyond what was actually entered onto the portal or sent to my JA, then what we will do is that I will print it, put it with the clerk's office, and give it to my clerk. During the trial, any evidence that is being collected or that's been admitted, if it has been admitted, I will print that particular exhibit and give it to my clerk. So you're ensured that at least based on the evidence that's been scanned and that's been prepared in your trial notebook, we will have access to that. On one of my trials, the lawyers were kind enough to prepare full trial binders and deliver it downstairs to BSO. I went personally downstairs, picked them up, and had them ready to go so that we could go and we can actually work with the actual binders. And there was, of course, each lawyer had a binder ready to go, respective binders ready to go. So that has worked out very well. I concur with Judge Bailey. Issues with photographs, color photographs, we have had several issues come up where there is a question as to when the injury took place and the color of the bruising. If you load it up, please make sure that you load up a JPEG, a color JPEG. We will not be able to go ahead and to literally print it and give it to the clerk's office. But if we have a color JPEG available during the hearing, we can actually load it up, look at it, and then afterwards, if it is admitted, I will give you the opportunity to supplement the record with a color photograph as soon as we're back operational and you have access to delivering it to the courthouse and filing it with the clerk. Judge Bailey, if you have anything else to add on that.
No, and the other aspect of the hearings that you got to be mindful of is there's a certain lag between you speaking and it being broadcast and being heard, so that it becomes very problematic during objections. Be sensitive to objections. If somebody's objecting, the witness is continuing to talk. The judge is trying to stop the hearing to deal with the objection, and it becomes a problem. The microphone is going to be activated on everybody, but everybody's talking and sometimes with raised voices. It becomes a problem of trying to get everybody to calm down, slow down the pace. I think the best way to handle a Zoom hearing is to go a little bit slower than a normal hearing to accommodate that lag in time. The problem that Judge Ledee talked about is there are witnesses who don't have access to a camera. They want to testify audibly, but not visually. Some police officers don't want to testify visually if they're home. We took testimony this morning of a police officer who sat in his car and testified from there. But if somebody is not visual, the judge can't see the witness and swear on the witness. It requires that notary. There's no shortcut. It's either I can see them, raise their right hand and swear them in, or they have a notary. Just to warn your witnesses of that, try to discern from them, is that going to be necessary? Do I have to advance plan that aspect of the trial? But otherwise, I think the evidentiary hearings have been going quite well, and getting the orders out quickly. How about you, Judge Ledee?
One of the issues, and I've had several of the lawyers, basically they appear on Zoom, the strength of their feed is very, very weak depending on where they are. One of the things that I recommend, and I just did it for myself at my home, was to increase my megabyte speed from 12 megabytes per second all the way up to 40 megabytes per second. And some of you may actually have higher speeds than that. So if you have the opportunity, contact your service providers and try to get that speed up to the maximum that you can. And the reality is that most of the providers today are actually discounting those services. And it was actually cheaper to do that than to keep it at 12 megabyte speed. So please verify the speeds that you're using for your modem services.
There is no objection, by the way, to a video feed trial or a Zoom trial, even an evidentiary contested hearing. That objection by itself is not going to be, it's not going to carry any weight with the court. However, there are limitations to what a Zoom hearing can do. We had a trial set for May that's going to take 2 solid weeks, including a number of expert witnesses, a number of protracted cross-examinations. And the attorneys and I all agreed that this is not suitable for a Zoom kind of hearing. So there is a limit to what you can handle reasonably with a Zoom. Complex litigation that's going to go on for more than a week, you probably would be better off setting that later for when the courthouse is back in functionality and handling a full hearing. But short of that, the objections to I don't want to do this by Zoom is going to be overruled. So just be aware of that.
We've been trying to accommodate literally every lawyer and every request that we've had, just to go ahead and to try to make sure that you have access to us. And it is incredibly important that your clients know that. We've been working literally from 8 o'clock till 5, 6:30 in the evening, working on Zoom and trying to make sure that we get that done. So if there's anything that we could be doing better, it is, and I've asked several of my lawyers if there are any recommendations that they have to try to improve this, please, we are open to that. And you're getting a snapshot into the future. You really are, because based on what we're seeing here today, I anticipate that UMCs and CMCs, at least in Division 33 and uncontested, as a courtesy to my lawyers, will go beyond this emergency, this time of emergency, and will go well beyond the pandemic. We're trying to make sure that you have access to us, but at the same time, if your clients can save some money and you can save some time, we're happy to accommodate. And that was one of the requests that was being made by some of my lawyers.
We're also seeing the term pandemic and coronavirus and COVID-19 coming up in a lot of pleadings, financial hardships created by loss of employment, loss of income, complaints that the estranged spouse is not practicing social distancing, is not taking adequate care of the client or of the child during the pandemic. We're aware of it, and we're dealing with them as they come up. We're evaluating on their merits as they come up, so that some attorneys have said, are we speed tracking anything for the coronavirus? We're going to treat every issue as we always have. And if it's a financial crisis brought on by unemployment for whatever reason, whether it's COVID-19 or some other reason, we're going to treat it on its merits. Ms. King, do you have any?
Question?
Sure.
So one of the first questions that came in is something that you just touched on, Judge Bailey, is how are the courts addressing modifications of child support and alimony in the wake of many people losing their jobs?
So today, I already kind of commented on that. Do you wish to add to that?
I'm hearing every case on a case-by-case basis. If there is a good faith basis for it, I'm hearing it. I understand the sacrifices that everybody's making at this time, and believe me, we are incredibly sympathetic to that. So I'm hearing it on a case-by-case basis.
Okay. Another question is, how is the court handling cases where one attorney does not have access to work remotely?
We were addressing that issue over telephone. I have, at least in my division, in my courtroom, I am able to go ahead and to have a Zoom hearing simultaneous as a telephone conferencing hearing. So lawyers understand on the telephone conferencing system, we can only bring in 3 people at a time on the conference call. So we've been accommodating the lawyers that way. And there are certain lawyers that just don't have access, or the feed is very, very weak from where they're broadcasting from. So we just use the telephone to do that.
Anything you want to add?
There have been times that there's a glitch going on. We can see the person, but we can't hear them, and we'll get them on the phone. So that it's not uncommon for us to have both the Zoom hearing and the telephonic going at the same time, as Judge Ledee indicated. And you've got to work out the feedback, so make sure that the microphone is off on one as opposed to the others, and to cut down on the calamity. But it's all workable. We work our way through it. What I do see though as a consequence is dockets take longer. You know, regular hearings take longer. Every hearing takes longer than anticipated. And we feel bad. We could see in the waiting room, quote unquote, the waiting room on the Zoom hearings, that there's 10, 12, 15 lawyers waiting, and we're trying to get to them as fast as we can. So that there's going to have to be a generous portion of patience doled out from the family bar as we work our way through this. Fortunately, if you're in the waiting room situation, you can be doing other things at your desk instead of just staring at the screen. So that's good on your end. And there have been many times where we bring in the lawyer finally, and they're not there. We're looking at an empty chair. We're looking at the corner of the ceiling. So that just be aware that everybody's trying to work through the same thing. I think you'll find the judges are very patient with these kind of challenges, and we ask the bar to be patient as well.
One of the challenges we have is that when you actually sign in, I know that some of you are using your children's iPads and some other, literally the telephone that you're using is not yours. Please, if you can actually sign in using your name, it makes it so much easier for us, because we're going through the waiting room trying to select which lawyers go with which case. And
last name.
It's been interesting.
We get a lot of Susan and Mark and John, so let's go with the last names. It'd be helpful. Ms. King?
Okay. Yes. How are the judges handling cases where one parent is an emergency provider?
It's the issue here. Specify what you mean by emergency provider.
So if a parent is either someone that is a doctor or nurse, someone that has possibly coming in contact with COVID-19 patients.
I have had a number of those cases where we've had both literally litigants that were involved that are actually right south of us at Broward General, and we've had a number of those. If that comes up, I will continue those cases and give them the time. Their priority is to take care of the patients that they're taking care of. That is their priority at this point.
If the question geared toward my concern is the child's father or the child's mother is exposed to the coronavirus more than the average citizen because of their work.
Yes, ma'am. Yes, sir.
The courts have gone into an inquiry into what precautions are being made. And if the court is satisfied that the emergency worker, the first responder, or the medical professional is taking all reasonable precautions and to protect from spreading the virus to the family, that's going to be honored. We're not going to be in a situation, and it's not intended. I don't find the request to come from people who are ill will, who are trying to get an advantage. They're concerned parents, and I respect that, but I'm not going to punish a first responder or medical professional for their diligent work trying to get us past this virus by taking away their children. As long as we're satisfied that they're taking all reasonable precautions necessary to avoid spreading the virus, we're going to continue the regular visitation schedule as it has been in the past.
Several hospitals have actually, several hospital districts have actually provided other locations for their medical staff and first responders to stay, literally targeting to make sure that they are not infecting their families. So that is something that the hospital districts have addressed directly.
Another question that we're getting is, how is the court handling parties who have supervised visitations? Most visitation centers are now closed. So is there anything the court's doing to address those types of cases specifically?
Ledee?
We have had very few of those motions. Actually, I think I've only had one, and this was a supervised visitation at Faces, and Faces actually did it over Zoom. So we have had that. That's the only one I've encountered, and it went relatively well.
I've not had that situation come up in front of me yet.
Judge Ledee, you spoke about having the binder submitted to the court. Is it each party submitting their own binder, or is this a joint binder that's being submitted to the court?
No, these are separate electronic binders. So basically what you have is that you have the case style. They will prepare a summary of exhibits, and then they will have each exhibit will be scanned in and actually labeled exhibit A for identification. If you want to add what the description is to that label, that's fine, but it should be exhibit A for identification. Let's say, basically a financial affidavit. Those will then be shared. Those electronic trial notebooks should be shared between the two lawyers. Anything that can be agreed upon should be detailed out to us as being agreed upon so that I can print them in advance. And then if anything comes up that needs to be admitted, that is going to be admitted, then I can go ahead and I can print it just simply based on that exhibit. It allows all of us to be in our remote locations and still have access to the exact document that has been referred to.
And once I bring up the document, I'll bring it up on the shared view in the Zoom image to make sure that this is the document we're talking about, and everybody can see it. That's the only way we can handle it is to put it up so that the same thing with photographs, same thing with anything. We put it up on the screen so that everybody can see what we're talking about. Am I clear? This is your exhibit. This is what you're offering as Exhibit 9, to avoid any clerical mistakes.
How is the court ensuring that witness testimony is not compromised when given by video? I think the question is asking specifically, how are we making sure that someone else is not in the room or helping the witness answer questions?
What we've done, what I've been doing in this trial is when the witness comes on, where are you? Are you at home? Who else is at home? Who else can hear you? I need you to be able to close the door. We had it in the trial this morning. There was a witness who was there, and his parents were there, and they were also going to be witnesses. So I told them to go out and tell the parents they can't listen in. I had them swear that there's no other computer in the house, that they could be watching on another computer to see what his testimony is, and so on. You take all the measures you can, and it does, in some aspect, rely on the good faith of the person answering the questions that he's going to do what you told him to do. It's not a perfect system, but right now it's the best we can manage.
I've had one issue where one of the litigants attempted to record the proceedings from a cell phone and swore that they did not. The only thing is their video feed is like we are here today, and of course the angle feed, what he was holding the phone was to the side, so it was inconsistent with his video feed on Zoom. We've had those types of issues happen. As far as soon as we instruct them that they are to be alone, once that's taken care of, I haven't had any other problems besides that.
The things you can do with Zoom is put in a fake background, Golden Gate Bridge or forest or something like that, and so that we don't know what's behind them. I highly doubt most citizens have a green screen available to them to really create a nice disguise. But I think so far we've been trusting when they obey the instructions. I think there's case law on that when a court gives a witness an instruction, the court is entitled to rely on the witness obeying the instruction.
How is the courts handling hearings with pro se litigants?
With more patience, as always, just try to help them understand the system. And we've had, little kids running around making noise. We had dogs and cats making noise. I had a witness who, on a domestic violence hearing, she was in her car, and I could see the child who was the subject of the domestic violence sitting behind her in the car seat. And fortunately, there was somebody else in the car with her. I had her step out of the car. I can't have this child hear this testimony. So that you got to walk them through the system that they don't understand anyway, and help them, even if they don't understand why you're taking these precautions, help them take the precautions that the court needs for the integrity of the evidence. Judge Ledee?
I've been doing it incredibly diplomatically, so that and if for whatever reason we encounter a situation where we have to ask someone to please relocate so that the background is not problematic, we do that. But most of the folks that are pro se have been, one, use Zoom probably better than some of my lawyers, and they're very familiar with the system. And at the same time, they're very respectful. So we tried to get them out. I'm still holding 8 o'clock hearings with my pro ses to try to get them out as quickly as possible. And that has been working out quite well. Most of the pro ses, whenever they get the letter, they actually are told that they need to be with a notary. And most of them will go to a notary and will sign in with a notary. The other issues are if for whatever reason they're doing it using their driver's license and they don't have an access to their driver's license, I take the information off of the driver's license and I run it into our David system so that we can go ahead and we can determine that that is the actual person that's there and that their picture matches up onto their driver's license and that they've been a resident of Florida for the last 6 months or whatever other identification purpose we use it for. But we've been very successful with the pro ses and they've been incredibly gracious with us.
Judge Ledee, have you had to deal with a foreign language interpreter yet?
I did a trial involving a foreign language interpreter, court reporter, and 2 witnesses in Colombia, and a hearing on that, and it went incredibly well. It's just the speed of the feed is critical, and as you mentioned, the objections are slightly delayed, so everybody needs to pace themselves. And once you get into it, it works very, very well from that perspective.
Ms. King?
Sorry. As a follow-up to the evidence question, Your Honors, what format do you want the binders submitted to you? Hard copies, by Google Drive, or what format? Just, do you want it by electronic or do you want it hard copy?
Photographs should be in JPEGs. That's probably the easiest way. And as far as the other documents, you can as long as they're in PDFs, we can open it up.
I don't require binders. If the exhibits, send the exhibits via email, and we'll take them just like you brought them in your briefcase into the courtroom. We'll deal with them as they come up in the hearing. I use the split screen method to put it up there, and again, if I had to do this with a jury, it'd be impossible. The fact that I'm the gatekeeper as well as a fact finder enables me to put it up, and I'll decide whether I'm going to consider it or not. But I don't. Maybe Judge Ledee's got a higher clientele than I do. My people don't put together binders. I'm lucky if they show up on time. But we're all good. We'll work through it.
Your Honor, I think to follow to that, there's a question on I guess it's 2 parts. What are you doing about objections to documents that are being attempted to be introduced? And also, what if someone has additional documents that they want to, I guess, utilize to rebut an issue that has come up during the hearing? How do they submit that?
The short answer is email. As far as the objections to the documents, all the standard objections apply. The rules of evidence do not suffer from the Zoom hearings, so that all objections, whether it's authentication or hearsay or any of the other documentary objections, still apply. And I will either consider it or I won't consider it in making my decision. The problem is more precarious when a witness says, well, I've got a document that I didn't send. They can send it right now. If it's an attorney, have their staff send it. If it's a private citizen, it's more problematic, but that's always the case. We've always had a situation where a witness is coming to the courtroom and says, I've got a document that disproves that, Judge. I just didn't bring it with me today. And we're always going to have that situation, and Zoom doesn't create a new problem for that. It's the same problem. You need to be prepared for everything before you go into that final hearing, and send it in via email so that we can address it in that final hearing. I had a witness tell me that I've got a video on my phone that disproves that, or I got a voice message on my phone that disproves that, but I can't get to it without disconnecting the phone call. And that leaves me in a situation where you're making it impossible for me to conduct the hearing at this point. You should have gotten that to us earlier. You should have submitted it earlier, because we can't go forward. This is the final hearing. Just as those people, 2 years ago said, I didn't bring my evidence with me to court today, I didn't know I was going to need it. This is the same circumstance. You do need it. And I'm going to make a ruling today. So figure out a way to get it to me, or stand by the ruling. Judge Ledee?
I do pretrial conferences on all of my trials, and issues like that usually get resolved right there, because I go through with the lawyers most of the evidentiary issues, any of the stipulations, any motions eliminate, and it allows them to basically address those types of issues. So I have not encountered that issue on the Zoom hearings that I've had, but I'm sure that they will pop up just like anything else. And if you can get it to me in time, I'll have a Richardson inquiry, and we'll just go through. The rules of evidence haven't changed, and the admissibility of documents haven't changed. So I'll just have a Richardson inquiry.
Does the court require to do anything different with notices to advise, I guess, witnesses and litigants that the hearings are by video?
We're sending out to all the pro ses get from our case manager, get a notice that they're going to be done over Zoom. We maintain the same Zoom meeting, basically access code, so that we don't have different meetings going on at the same time. It's just one meeting, and we will keep on renewing that 30-day at a clip. As far as the lawyers are concerned, my procedures are on the website. They can follow specifically what we're doing via Zoom. And if they have questions, I can tell you that most of them just email Barbara, and she responds to them literally within minutes.
I shared Judge Ledee's positive comments about the pro se litigants. I'm very pleasantly surprised at how well they've been following the instructions that are on the website and handling the Zoom process. I've been surprised, and it's all been positive.
How are the courts handling court reporters for Zoom hearings and creating a record?
Most of
violence, we bring in the blue man as a court reporter, so the electronic court reporting is taking place for regular FMCE hearings. It's up to the parties. Somebody brings a court reporter on, and they're brought in like anybody else. They're brought in at the beginning of the hearing. I'll ask, has anybody got a court reporter, and what's her name? Because we got to find that in the waiting room, and bring her into the hearing just like everybody else, just muting her microphone, his or her microphone.
Some of the court reporting firms have developed Zoom rooms and have actually set it up so that the lawyers can go to the court reporter's office and with the witnesses, or the witnesses can go there, and they set it up in Zoom rooms. And that's been very effective because they have multiple camera angles as well. And that has worked very well for us.
Zoom rooms. So we now have new vernacular, Zoom rooms.
Can you clarify the administrative order regarding that came out, I think it was 2 weeks ago or a week ago, that from Broward County regarding time sharing?
Judge Bailey, this one's yours.
I don't know. I'm trying to understand the question.
I think the question is regarding the administrative order came through, I think, a week ago that said that time sharing must continue under normal circumstances, but there's also some language that says if there is a state order in place that requires parties to shelter in place, then the parent with the 183, the majority of the time sharing should be able to keep the child, and then the other parent would be allowed makeup time sharing. I think there's just some confusion between the one section that says time sharing should continue, and then I think further down it has some but if this occurs, and I think that's what people are asking about.
The way I've handled it, and I don't mean to be outside of any administrative order, but the way I've handled it is I treat the exchange between parents for the child visitation as an essential service, and allow that to take place. And any attorneys ask for an order to that effect, I issue an order so the client can have that in the car if they get pulled over for why are you out and about with a child in the car. That this is an exchange for child visitation and it's an essential activity. The more challenging aspects of the visitation have been the long distance visitations, the children who are like spring break coming and going, and the child is out of state and it's a long distance sharing situation. I have not allowed the children to travel interstate for the purposes of visitation. I shouldn't say I've not allowed it. Where anybody who's asked that it not take place, I've granted that request because of the current situation and the increased risk involved in travel. So I don't expose the children to increased risks. But on the local level, mom and dad, local in Broward County or in the Tri-County area doing visitation, I've allowed it to go through without a break.
What I've done in those circumstances is that I've inbuilt a 14-day quarantine period. If the child is out of state with one parent and there's a request for a pickup order or return to the state, I will inbuild 14 days so that the child has to be quarantined for those 14 days to minimize the risk upon return to the other parent. And what I will do is that I will address the issues of makeup time sharing afterwards.
And to follow up on your the issue of the summer time sharing, the question is, what are we doing about long distance time sharing, especially with summer approaching? And I think both of you just answered, but I just want to clarify. Each of you are saying that you'll address it as the issue comes along on a case-by-case basis.
Correct. I think, especially for the summertime visitation, by the time those dates roll around, hopefully there'll be a change in circumstance with the restrictions on travel and restrictions on sheltering. As we get out of April and into May, I take the experts at their word that they're going to see a lightening of the restrictions taking place. Hopefully by June, we can get back to some level of normalcy. So you take it on a case-by-case basis as to the dates involved, the type of travel involved, whether it's international travel or interstate travel and so on. But right now, during the crunch of it, and I think we still are in the worst of it, I understand the request not to travel via airlines, and I honor that request. And like Judge Ledee says, we're going to have to sort this out later by a balancing of overnights to get back to the schedule everybody intended in the first place.
The intent is to comply with the CDC requirements as well as the governor's instructions to the population. So we're going to make sure that those orders are complied with. And remember, it's in the best interest of the child. So we're always going to err on the side of making sure that the child is safe and that in no way is the child going to be, infected with this virus.
And there's a question asking for clarification regarding the domestic violence hearings. One, to clarify, a domestic violence hearings being heard by Zoom, and two, for the video hearings, is the court providing interpreters?
I've not had the interpreter issue come up in a domestic violence hearing yet. The short answer is yes, we're doing domestic violence hearing, full evidentiary hearings. I'm on day 2 of the long domestic violence hearing right now, so that those hearings are taking place as scheduled. The but I have not had to do with an interpreter yet. We bring the Blue Man system in, the electronic court reporting system in. If for some reason there's a glitch on that, Zoom is recording automatically, so that there's no risk of it being lost. On civil, not on civil, but FMCE hearings, I'll go ahead and pause the recording unless the attorneys want me to continue to record it. But for domestic violence, we're recording all the time. Judge Ledee?
Same here. We have not had that issue come up. In case we've made a request or to have interpreters on standby if we need them during DV hearings, but that issue has not come up. And until it does, I'm not quite sure the technical aspect of it. If it's going to be over Zoom, the interpreter would have to be in one location, and basically the live feed would have to be good enough for the interpreter to hear and to translate for us.
There are a lot of questions about how the court's dealing with discovery issues and difficult opposing counsel. So I'll try to like lump it all together. So essentially the issues are some opposing counsels, of course, are not agreeing to mediation by video nor depositions by video. And with hearings approaching, a lot of the attendees want to know how should they address this with the court.
Part of what controls my decision on that is the age of the case. If it's a 2020 case and we're in the early stages of it anyway, I'm far more likely to give some leeway. Let's postpone the depositions and see what happens with when the courthouse is going to return to normalcy. But not on discovery, not on interrogatories or requests for produce and so on. There's no reason for that timetable to change at all. So all those rules remain in full force and effect. But if it's an older case, it's been pending for 3, 4, 5 years, or it's a modification that's been pending for over a year, I'm less inclined to listen to the argument that I don't want to do a video deposition. I want to be in the same room. I want to see the eyes of the person I'm talking to. I agree that's the optimal situation, but I think everyone agrees we're not in the optimal situation, so that I'm not going to stop the progress of cases to hope for the optimal returning sooner rather than later. I still think that we're going to be out of the woods on this by the middle of summer, but we may not see normalcy, however you want to define that word, come back until much later in the year, if this year at all. Does a day?
The issue becomes, what's the end goal? If the end goal is to resolve the issues that have been raised in the petition, there is always ways to compromise. Remember, the attorneys are not only attorneys at law, but they're also counsel to their clients. And I remind my lawyers all the time, I know that the litigants may be difficult and they may have certain demands of you and that type of thing, but you are counsel to them. And the issue becomes, if we can resolve small issues at a time, I'm happy to do that. I also caution some of the lawyers. Remember that when you are an email chain and you include my JA, she sees everything that you are going back and forth. And sometimes the language could be a little colorful. So please be careful of that. She's very good at protecting all of the lawyers and making sure that that never gets to me and that I don't find out about it. But I can tell you that she does see quite a bit sometimes that goes back and forth. So that's a bit of a challenge. At the same time, she has instructions from me to make sure that if I can go and I can give time to the lawyers to resolve even small issues, I will accommodate lawyers so that they keep maintaining contact with their clients and keep their clients informed. At this point in time, keeping the client informed is critical because with everything that's going on, they have no closure, and we're trying to make sure that that happens. So just remember what the end goal is and bring your clients to that end goal is important.
I know you guys already addressed this, but some people may have came in late because I'm still getting this question. What are you doing when both parties do not agree to a Zoom hearing? And I know you already addressed this, but some people may have came in late, so.
The Zoom hearing is going to take place. The only reason why My practice in this division has been the only reason why I will not do a hearing by Zoom. It is a complex, highly contested, litigious action that's going to take more than a week to resolve it. I'm not going to do a 2-week trial on Zoom. It becomes too problematic. It's the logistics of coordinating witnesses, expert witnesses, quantum documents becomes a bigger problem the bigger the trial gets. But for an evidentiary hearing, whether it's domestic violence or a regular marital family division, it's going to be Zoom. And certainly at non-evidentiary hearings, it's going to be Zoom. We cannot afford to stop our actions in these cases, allow these cases to build up behind a wall like a dam, and then when we return to normalcy, we would hit this with this tsunami of cases that have been backed up. To avoid that logistical disaster, we got to keep moving forward, and especially when there's kids involved. You know, it's too important for us to sit on the sidelines and hope.
I agree wholeheartedly. We're going to keep on doing what we're doing. We're going to be accessible to the lawyers. We're going to be accessible to the litigants. It's making sure that they have access to us and that their issues can be resolved in a timely manner. Just the fact that we're in a pandemic, it doesn't mean that we're going to change what we are doing. We're just going to do it smarter. And you're getting a snapshot into what may actually be the virtual courtroom of the future. And we're only at the beginning. So that's why I'm reaching out to all my lawyers and telling them, listen, if there's something that we can do better, please tell me, because making sure that we are accessible to you and making sure that you have literally the tools that you need to practice your trade, that is the key factor in what we're doing right now. So we're learning together. And at the same time, I've had incredibly positive response from the lawyers as to how we can actually do this and do it better.
I think that's about all the questions. Oh, wait. Is there anything? Oh, what if there are practitioners have Zoom hearings that are scheduled at the same time? I guess motion calendar Zoom hearings. How are you handling practitioners having multiple hearings at the same time?
Same way we handle them when their body's in the building. If they're in front of another judge, I'll be patient on it. As Judge Ledee pointed out, we see the list of everybody who's in the virtual waiting room. And you can tell that who's been there the longest and who's been patiently waiting. There have been times when I've reached out to that attorney saying, you may want to call your opposing counsel and find out where they are. And they come back and said he's in a Zoom hearing in front of Judge Davis, or he's in a Zoom hearing in front of Judge, Navarro. And so that no problem. I'm going to be here. I'm going to be here all morning until everybody's out of the waiting room. I've got more patience than the attorneys because they're the ones who are waiting by the phone. It's harder on them than it is on me. So that we'll just stay to it and stick to it and cover every hearing as soon as we can. And sometimes it requires biblical patience.
We're here, we're going to do it, and we're here to support the lawyers. So that's as simple as it gets. We're not going to change the service, the way that we service the lawyers. So we're going to keep on doing this.
And I think we're almost out of time because it's at 12:50. So I'm going to let you guys have some parting words. There's one thing, I guess, that the in-house mediation staff wants us to let folks know, that the in-house mediation is doing mediation by video and that they are open and still accepting business from referrals, I'm sorry, from the court. So parting words, Judge Bailey and then Judge Ledee.
As you can tell from Judge Ledee, he does it from the courtroom. I do it from my chambers. I know other judges are doing it from their homes. And Judge Ledee said repeatedly, and I can't agree more, it's all about getting it to the end game. In some respects, we all have the same interest. We're trying to get good, reasoned decisions, fair and just decisions as quickly and as efficiently as possible while maintaining everybody's rights to be heard. We're learning as we go through this process. We appreciate the patience of the witnesses and the attorneys who have been waiting longer than usual because the process takes longer than usual. but we're here to serve you guys, and we appreciate all the feedback you give us. Thank you.
I want to thank all of the lawyers because truly you have been incredibly supportive of this process and have done literally a very, very good job of trying to facilitate these hearings. So we are going to remain accessible to you. Please keep doing exactly what you're doing by contacting Barbara by email and making sure that she's aware of all your contact information. Make sure that you're available at the time. When you sign in, please sign in using your name. What's happening is that Barbara or Janine will actually pair up the lawyers on a particular case and tell me who's in the waiting room. I see it, but sometimes I'm not able to decipher who it is because you're using somebody else's iPad. So they're trying to figure that out. If for whatever reason there's an issue, we will try to accommodate you and bring you in. And like I've rescheduled certain things for this afternoon that we couldn't finish this morning. And just be patient with us. We will get to you and we'll make sure that you have access and that your clients have access to us. That's my primary goal.